Hello all, welcome to SSC Masala. This is an English medium channel. If you want Hindi explanation, then you can join the main channel. In this video, we will talk about CGL to 2024 court case. A hearing was done on 22 April 2025. I will give update about this, and we have some idea that who can win the case. And also we will talk about CGL 2023 Supreme Court case update. So currently the CGL 2024 court case is ongoing in CAT, and the petitioners, stupid arguments were given by petitioners. Petitioners means the candidates, the students who have filed the case and their advocates. So today the stupid arguments given by them were that they give argument against the multiple shifts and normalization in the mains exam of CGL. They were asking that why multiple shifts and normalization were done in the mains exam. Is this a question to ask? The SSC had the simple answer that it is their procedure. This is how they are doing since a long time. So they simply said, and also they didn't have any reply to the question of judges. The judges said that the multiple shifts and normalization was also done in the pre-exam, but that time you didn't came to us, you didn't complain at that time, then you cannot complain now. And the petitioners, I mean the advocates of petitioners, they didn't reply anything. They should have told the judge that the pre-exam is qualifying, its marks didn't get added to the merit, and also many lakh students give the pre-exam, so it is not possible to conduct the pre-exam in a single shift. And of course, when the exam will be conducted in multiple shifts, normalization would be done. But in the case of mains exam, it is not so. The mains exam could have been conducted in a single shift. It was conducted in 2 shifts, but if SSC wanted, it could have conducted it in single shift. Then they argued against the final answer key after the result. They said, why final answer key comes after the result? The SSC simply said that it is their procedure. They are just following the procedure. They give the final answer key after the result. The judge also said that yeah, they are following their procedure, and they didn't reply anything. They should have said, they should have told the judge about the preference form. They should have said that the SSC takes preference form even before the result and the final answer key. So it is like shooting in the dark. The candidates didn't know their final marks, neither they know their result. I mean, they don't know their rank. So how could they fill the preference form? How could they know that what post can they get and in which post they can get their home zone or home location? The judge is not omnipotent. He doesn't know everything. You have to tell him. You have to tell in the argument, you have to tell the judge, and on the basis of your argument, the judge will take the decision. Then a stupid argument was done. They argued against giving bonus marks to those who didn't attempted the questions. What is this? If a question is wrong, a candidate may have left the question. If a candidate has left the question or not attempted the question, it doesn't mean that he will not get the marks. If a question is wrong, he might have left the question because he didn't want negative marking, right? In fact, they should have argued about that why bonus marks were given to all in the questions which were correct. Giving bonus marks in the correct questions is the wrong thing. They should have argued about that thing, but they did no argument about the main issue. They should have argued about the questions which were correct, and they should have give proof about that, but that was not done. So as a result, there was no stay on joining. So the appointment letters will be distributed in the Rozgar Mela on 26 April 2025. And the next hearing will be on 5 May. In fact, the judge was he was ready to give his judgment on the basis of this today's hearing only, on the hearing of 22 April. But then the petitioner, the advocate of petitioners, he asked for 1 week. So the judge gave the next hearing date on 5th May. So on this date, the questions will be discussed. But if they will give arguments like this, then of course the petitioner, the candidates will lose the case. 100% they will lose the case. So on 5 May, the SSC will also give its explanations. So the candidates and its advocates should have proper arguments, anti-arguments, the explanation of SSC against the explanations of SSC. Now let's talk about the CGL 2023 Supreme Court case update. So the thing is simply that nothing has happened yet. The case was registered on 20 September 2024. 7 months has passed, but no hearing has been done till now, not even a single hearing. Actually, the SSC and its advocates are playing the game of delaying. Every time the case is listed, the advocates of SSC, they ask for time. They ask for 3-4 weeks time. So they are just delaying the case. They are passing time. They are wasting the time of candidates. This is the information of the case. This is the case number. This is the case number, and this is the CNR number. You can simply search on the website of Supreme Court and you can get all the details of the case. The last time the case was listed on 25 Feb, okay, in 2025, and tentatively the case may be listed on 5 May. Means it is not final, but it may be listed on 5 May. So hearing may be done on this date. Let us see what happens. So this is the listing process. On 13 the case was filed, and on 20 September the case was registered. Then on 24 October SSC asked for more time, so time was given. Then on 12 December the case was listed again. Then again they asked for time, then time was given. Then on 27 January the case was listed again. The SSC asked for time and they were given 3-4 weeks again. After that, last time the case was listed on 25 Feb 2025. Then also 3-4 weeks were given to SSC, but it was written there that it was the last time. Okay, last time they were given time. After that, time will not be given. So the case should have been, there should have been an hearing in April, but there was no hearing. Now tentative date is 5 May. So let us see what happens. When the opponent is like SSC, which is very rich and powerful, then the candidate should also have money, but it is not so, and nobody is helping them. So what can be done? Otherwise the hearing would have been done in April. If candidates had enough money, then the case would have at least one hearing in April. But let's see, the hearing might be done in May. For updates, you can join my Telegram channel. The link is given in the description box. If the link does not work, you can simply search on the Telegram SSC Masala ENG. You don't need to type it on in capital letters. You can type in running letters. You will get the channel.